Welcome once again to Lehto's Law. Here's Steve Lehto.
Josh sent me a note and said, Steve, check out the story from New Jersey. And it involves a judge on the bench. And many judges get assigned to different sections of a courthouse. So there might be a judge who oversees a lot of cases involving business law. There might be a judge who oversees family law, and so on. Criminal cases, civil cases. And they often make these distinctions to divide up the work. So there's a judge in New Jersey who was assigned on a periodic basis to sit in family court and would apparently tell the people who appeared before him, I don't really know what I'm doing. I'm just up here, but they put me here, but I don't know what I'm doing. And I'm paraphrasing there because I'll give you the exact quotes in a second. But an official complaint, a formal complaint, has been filed with the Supreme Court of New Jersey Advisory Committee on Judicial Conduct. And I often do wait until lawsuits get resolved before I talk about a lawsuit. But a lawsuit is just allegations made against somebody or an entity. Here, we've got an allegation of things that a judge said while on the record. Those statements are made in open court, and there's a recording of them. So unless somebody literally made this entire thing up, which of course would be a big news story in and of itself, it seems like there's an awful lot to support the allegations that are making the news right now. But again, just to let you know, this has not been adjudicated yet. This is simply the formal complaint brought by the counsel, the attorney, for the Advisory Committee on Judicial Conduct, complaining against a judge named Michael Castle. So Castle is a member of the bar of the state of New Jersey. He was admitted in 1982. At all times relevant here, he served as a judge of the Superior Court of New Jersey, assigned to the Civil Division in the Camden vicinage, a position he continues to hold. On or about April 10th, 2021 through June 15th, 2021, he was temporarily assigned to the Family Division 1 day per week to address a management need. Presumably one section of the court was overloaded with stuff, so they said, dude, 1 day a week, can you just take some cases and relieve some pressure over here? On 16 separate occasions, he's alleged to have, while serving temporarily in the Family Division, made remarks to litigants and their attorneys, appearing before him that he lacked familiarity with their case, was ignorant of the applicable law, and incapable of adjudicating family court matters, and expressed dissatisfaction with the temporary assignment and the method by which the assignment was made. He openly expressed disagreement with rules, and that one rule he talks about relieves a defendant of the need to file an answer, appearance, or acknowledgement in the summary family action, provided the defendant appears in court on the same day. So he said, hey, look, the rule says you got to do this. I don't think so. On or about April 21st, May 12th, May 19th, June 2nd, and June 9th, all of 2021, respondent made the following remarks to multiple litigants and their counsel in 16 separate court matters. In one case, when addressing the issue of parenting time during a virtual court proceeding, he stated to the litigants and their counsel that he, and this is a quote, knew very little about the applicable laws. Having not served the Family Division for 2 decades and having removed that which he may have remembered from his mind, respondent compared his involvement in the matter before him to that of a cardiologist seeing his first patient. Finally, he remarked that he had not read the documents and did not understand that which he had read, but agreed to hear the matter if counsel would, and this is a quote, walk him through their issues step by step and treat him like a 9th grader in high school. On another occasion, while hearing an application for child support, he stated to litigants, I am not a Family Division judge. I'm a judge helping out. I am not a Family Division judge. I have no expertise in family law. I know nothing about this case. I know nothing about you, the litigants. So you can imagine how that makes you feel good when you go in front of a judge who tells you, I don't know the law and I don't know you. Proceed. On another occasion, while addressing litigants and their counsel, he stated, I'm working full-time in the Civil Division, and I'm literally in the middle of a jury trial that I interrupted to take my Family Division Wednesday. I have no idea what's going on in this case. Zero. So you're dealing with a judge that's completely inexperienced and untrained in the Family Division. Respondent requests the attorneys walk him through their case. They're going to have to walk me through their evidence. Respondent continued by stating, "Don't assume I know anything about the law or about this particular case. It's going to require both sides to walk me through the case like they were walking a fairly well-educated first-year law student." And now, I got to give the guy credit because he actually said something about not knowing anything, and he said, "What's going on in this case?" And he said, "Zero." That's something I often say. I do not have any idea about this. I literally, zero. And I sometimes say zero, just an indication that when I say nothing. Anything going on over there? No, nothing. Zero. So, I'll give him credit for that. But what's amazing about this, I'm going to get back to some of the other crazier stuff he said, is that the judge who says to the parties, "I know nothing about this area of law," is not that far-fetched, but there's a better way of handling it. Because I can tell you, in 31 years of practicing law in Michigan, specializing in lemon law, I have appeared before probably a dozen judges, maybe more, who have admitted out loud, "I've never handled a lemon law case before, so I may ask some questions that you may find odd, but you may have to answer some questions for me." And so they express the lack of familiarity with a field of law, but they don't say they're incompetent to delve into it. And here's the thing. The blue books behind me are the law books of Michigan. Michigan's compiled laws. Not everyone knows every law in those books, but an attorney and a judge would know how to look the law up, how to read a law, and then figure out how to apply it to a particular case. And so in many of these instances that we're talking about here, there were litigants with attorneys on both sides. They're in front of the judge because there's something they cannot resolve. If they could resolve it, they wouldn't be there. So what happens is, let's assume both sides draft briefs. They explain their side and what they think they're entitled to. They explain their side and what they think they're entitled to. And these two, of course, are opposing viewpoints. A judge can read both briefs and make a ruling. You don't know the law? Read the brief. Guess what? If you read the brief carefully, you'll know the law. So for a judge to come out and go, "I don't know the law, I don't know your case, I'm sorry, I'm just like a ninth grader here," or a first-year law student. Maybe you should read the briefs and do some homework, because unfortunately, there are some judges out there who act like their job starts at 9 a.m. and ends at 3:30, and they get an hour and a half for lunch. And so if there's stuff they've got to read, but they've got a trial going, I've known judges who wouldn't read it. But it's part of your job, okay? So in another case, during a hearing in respect of a custody application, respondent advised the parties and their counsel, "I do have some paperwork, but I want to be perfectly candid. I don't usually know what I'm looking at when I'm looking at the paperwork. I don't know what I'm looking at. I don't understand some of this stuff." He then asked plaintiff's counsel for an explanation of the application and the relief he sought. In another case, he said, "Let me advise the litigants that they've drawn a judge that's not in the family division for almost 20 years. He then went on and said, "I want to be 100% transparent. I'm not a family division judge. I'm a civil division judge, and it's been almost 20 years since I last sat in this division. Everybody ought to be aware of my own limitations. I'm not an expert in family law. It's not my choice division. I'll do the best I can. I know zero about this case. I have some documents before me which I'll be glad to look through." So he's basically saying, I'm unprepared. I didn't even look at the documents. Sorry, zero. During a hearing to modify child support, respondent stated, "The litigants ought to be aware that the last time I handled family division matters was 18 years ago, and I'm filling in because of the shortage of judges in the family division." Now, those statements are true, but they don't exactly lend credibility to the court. You know, the judge is supposed to know the law because the judge rules on the law. And if he's going to make rulings, but admit he doesn't understand the law, there's a problem. Respondent advised the litigants that he last sat in family division 18 years ago in another case, and stated he moved the date of the hearing to give plaintiff time to file opposition because respondent felt the court rule allowing an opposing party to verbally state opposition on the day of the motion hearing without filing any papers is very unfair. And so he's moving stuff around in violation of rules that he thinks are unfair. In another case, he encouraged the parties to work out a parenting schedule stating, You both sound like reasonable people. I would encourage the two of you, frankly, particularly compared to some of the litigants I had several hours ago, the two of you sound fairly reasonable. He discussed proceeding to mediation since they are more experienced than respondent stated. Frankly, you could get a guy off the street that's more experienced than me with this stuff. So he's constantly belittling himself and saying, I've got no ability to do this. And if the judge is sitting there telling you he's incapable or incompetent and he can't do his job, he shouldn't be sitting there. And so, as you can imagine, if you worked for an airline and one day your manager called you up and said, hey, the ticket counter you normally work at? Yeah, I need you to fly the plane today. Would you actually go into the plane, sit down and go, I guess I'm going to fly the plane today? No, it's not your job. So if somebody says you be a family court judge and you are incapable of doing it, you have to tell them, I'm sorry, I'm incapable of doing that. Now you might say, but Steve, if he does that, might he lose his job? I suspect these are elected positions, but there's going to be a chief judge and somebody who's in charge here. And if the guy says, I cannot do my job, might he lose his job? Possibly. But if you get elected judge, and part of that is you might get assigned to family court, that's part of what you signed up for. In another case, he advised the parties that he had no paperwork and doesn't know anything about the case. In referring to the cross motion that was 150 pages thick, he said, obviously, I'm not going to be able to read that, and I haven't even looked at the original motion. Let me look at the motion and see how bad it is. I've always wanted to say that in response to something my opponent filed. In another case, the parties appeared before the respondent in respect of a motion filed by the defendant, which respondent commented had included 150 exhibits. He stated, here's the bottom line. If you both want to submit a much shorter version, let me tell you something about myself. I've been a judge now almost 20 years. The last time I sat in the family division was 18 years ago. It gets even worse. I didn't handle FM motions. I didn't deal with the divorce cases, and they put me in as a supplement on Wednesdays, obviously because it was an emergency. He likened himself to an obstetrician in the hospital when a patient comes in with a broken bone and the doctor has to treat the patient, stating, that's the way you ought to view me. I'm the OB confronted with people with broken bones. Maybe that's a bad metaphor, maybe it's not. But the parties ought to be realistic as to what they can expect me to do until the judge comes back, the other judge. So maybe his example is better than mine of the pilot and the ticket taker. Who knows? But, we do what we can. In another case, the attorneys advised the respondent, that's the judge, they were going to mediation and potentially a trial would be necessary to address child support issues. The judge expressed his displeasure with his temporary assignment, stating, as a matter of fact, by the time this conference call ends, if I'm still in the family division, I'll be very unhappy about it. But it's unrealistic to expect my liberation from the family division is going to be sooner than that. And these things go on and on. But some other examples of slightly different behavior. On one occasion, he appeared in the courtroom with his feet propped up on the desk, not wearing his robe. Now, presumably he had other clothing on, but he wasn't wearing his robe. Turns out there's a rule in New Jersey that a judge who is presiding must wear a judicial robe to indicate. And the complainant here who's filing this with the judge, against the judge, says that impugned the integrity of the judiciary and the solemnity of the court proceeding in violation of the judicial canons of conduct. Also, there were other allegations. Like I said, this goes on for 9 pages. 9 pages. But the final prayer for relief in this matter, it's a formal complaint. It says, wherefore complainant charges that respondent has violated the following canons of the Code of Judicial Conduct. First, the rule that requires judges to observe high standards of conduct so that the integrity and independence of the judiciary may be preserved. 2, the rule that requires judges to avoid impropriety and the appearance of impropriety and to act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. 3, the rule which requires judges to maintain professional competence in the performance of their judicial duties. Judges are required to stay on top of their game. They're required to stay sharp. They're required to know the law. If you go to law school and you become a lawyer, you can't forget what you learned in law school just because you're now a lawyer. Likewise, if you become a judge, you can't forget all the law. Hey, now I'm a judge. No, that's not how it works. It's not how it works. Fourth rule, which requires judges to maintain order and decorum in judicial proceedings. And another rule, which requires judges to hear and decide all assigned matters unless disqualification is required by the canon or other law, and to disqualify themselves in proceedings in which their impartiality or the appearance of their impartiality might reasonably be questioned. There's a rule that requires them to wear robes, period. And another rule that requires judges to disqualify themselves in proceedings in which their impartiality or the appearance of their impartiality might be reasonably questioned. And I didn't get into some of those where they're talking about possible conflicts. But the real problem here, and it appears to have been a pattern, and again, these are just allegations, but I'm assuming that because all these things appear in quotes in all these documents, that there's a record of this. And I suspect it came to the attention of the people in charge because attorneys were walking out of there going, did you just hear that? Did you just hear that? And they found all these examples. And the basic thing the judge was saying is, I was assigned to this job, but I don't really like it, and I'm not qualified for it. But here I am. And that right there is such a bad thing because I've talked before in the context of why you dress up when you go to court, right? I've had people say, Steve, why would I dress up to go to court? Why can't I go to court wearing a Tucker t-shirt and blue jeans? Because you should show the court respect because the court's going to show you respect. And respect and, things having to do with manners are two-way streets, right? I respect you, respect me. I'm polite, you're polite. That's how this stuff goes. So you go into court, you dressed up nice, you have a lawyer, you're paying money to be there. The lawyer spends a lot of time here, but you don't come here that often. And out walks a judge saying stuff like, I don't want to be here, I don't even know anything about this, I don't know who you are, I haven't read your stuff, but fine, I'll rule. How much confidence does that give you as a litigant in the legal process? And keep in mind that this is happening in family court. Family court is already fraught with peril. And I've mentioned before, I've said, I do not want to be a judge, have no inkling, never wanted to be a judge. I would, if you said, Steve, would you be a visiting judge for 2 weeks? You get to be a visiting judge, we'll swear you in, give you the robe for 2 weeks. You can be the visiting judge someplace. I don't want to do it. I don't want to do it. And there's stuff it would involve that I would find unpleasant. And one of the things is that I might get stuck doing something I don't know much about because district courts, for instance, in Michigan handle landlord-tenant matters. Now, I used to do landlord-tenant stuff 30 years ago, 29 years ago. It's been a while since I looked at it. I'd have to brush up on it. But that's the part I don't like. It's not that I'd go on the bench and be incompetent. It's that I would feel so pressured to be competent that before I became the judge, I'd have to do tons of homework on the various fields of law that I know would come up. But here's the problem. Family law, unfortunately, is a field of law, and I know attorneys who practice in the field, good friends of mine, where both sides are often, how do we say this, more emotionally invested in their cases than they would be in another setting. So I've seen lawsuits involving large numbers where people weren't as upset as they were in family court fighting over stuff like this. And I'm not saying it's wrong. I'm just saying that's the nature of the situation. People involved in family court matters quite often are very, very emotional about it. And so when you have a situation where people on both sides are already emotional coming in, they've got their attorneys, they come in front of the judge, and the judge goes, I don't know anything about this case, I don't know anything about the law, but go ahead. And you're already in that charged situation. It's not good. It's not good. So as of right now, the complaint has been filed. I'm not sure how long this process takes. It's different from every state and goes state to state, of course. And I couldn't find the front page right now. My life depends. Oh, there we go. Where'd it go? It's in my hand. But there's 9 pages to this complaint. And I don't know how long it takes. I suspect it won't be that long, maybe a month or two, but we'll see. But, the Supreme Courts of the states often do jump on these and rule on them quickly. because the concern is that if this guy is still seated in that courtroom doing those kinds of cases, he might keep doing this kind of stuff. So we'll see. But like I said, this is a formal complaint. It has not been adjudicated yet. So for all we know, the guy's going to come in, defend himself, and they're going to find that none of it happened. But we'll see. We'll see. So that's in the matter of Michael J. Castle, who's a judge of the Superior Court. And this is a formal complaint filed with the Supreme Court of New Jersey Advisory Committee on Judicial Conduct. Josh sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Come on, Ross, you're a paleontologist. Dig a little deeper.